Good morning, afternoon, whatever time this is you're watching this. It's morning for me now. We are going to comb through American legal systems and the courts. We have a chatty Betsy back there, and then public opinion tomorrow. So I'm going to get through 2 chapters this week because next week you will have your second exam. Like I said at the end of the video last week, I'm giving you all 100 for your third quiz. Since we've had so many technical difficulties, I thought that would be the easiest for everybody to kind of get everybody back on the same page. All right, let's comb through American's legal system in the court. It's a really interesting week to be doing that because probably tonight we're going to have a new Supreme Court justice. Amy Coney Barrett's vote in the Senate on the full Senate floor is tonight. Probably tonight. We'll kind of see how that goes. And so we will. It's history in the making as we're talking about it today. Okay, so what's at stake when the Supreme Court gets involved in partisan politics? It's a cherished narrative in American politics that justice is blind, and the Supreme Court is supposed to be this apolitical, impartial dispenser of that justice. But the Supreme Court is very political. There's no more classic example of it than the election in the year 2000. Between George W. Bush and Al Gore. There was a 5-4 decision in Bush versus Gore to determine the election. Hi, baby. Hey. Alexander Hamilton wrote in the Federalist Papers that the Supreme Court would be the least dangerous branch of government because he said it didn't have the power of either the sword or the purse and can do little other than judge, that there was no raw politics, no raw power politics involved. But 200 years later, the Supreme Court took the very political role of deciding who the next president would be in 2000 in Bush versus Gore. They overturned the decision of the Florida Supreme Court that allowed a recount of votes in the contested Florida election and awarded the victory to Bush. Florida was virtually tied. There were recounts required in some areas. Some votes were left uncounted. There was maybe a system failure that had rendered them invalid. That was in dispute. Al Gore thought a recount would help him, but Bush didn't want that. So the Florida Secretary of State was a Republican appointed by the governor, who was George W. Bush's brother, ordered that the vote counting be finished. And Florida Supreme Court said a recount should go forward. So Bush appealed to the Supreme Court, and the court was divided. But Justice John Paul Stevens said the loser here is perfectly clear. It is the nation's confidence in the judges as impartial guardians of the rule of law. I mean, politics had gotten super involved there. Had Bush really already won and it was up to the Supreme Court to say the legitimacy of his claim to power, or did the Supreme Court engage in politics so blatantly as to do irreparable damage in the eyes of the public? It's hard to know. Imagine a world without laws, right? You can speed, you can park where you want, you can enter a store that sells drugs of all sorts, purchase what you like without proof of age or a prescription. There's no rules governing the production of currency either, so you hope that the dealer will accept your offer and trade, and then your car is stolen, which isn't illegal, and there's no cops to call anyway. That's a world without laws. In chapter 1, we talked about Hobbes and Locke, who said, imagine sort of a pre-political world without laws. Hobbes said it would be solitary, poor, nasty, brutish, and short. Locke just said it would be inconvenient, and you'd have to constantly just be on the defensive without laws. But Hobbes and Locke thought that people would be willing to leave the state of nature for civil society, to give up their freedom to do whatever they wanted in order to gain security and order and predictability in life. Do you guys remember Lord of the Flies? You probably read that maybe, 8th or 9th grade. It's kind of this lawlessness, right? And what has to come of it. Order eventually comes. We focus on laws that stop us from doing what we want, but we don't think about the laws that allow us to live together peaceably. Laws are the how and who gets what and how in politics. It dictates how collective lives are to be organized, what rights we claim, and how to use the system to get what we want. Laws can also be the what, as citizens and political actors kind of use the existing rules to create new rules that produce even more favorable outcomes. So laws in the American legal system, laws are limitations and restrictions that get in our way or make life easier, but our legal system is also founded on rules that represent basic and enduring principles of justice that create a higher level of civilization. Laws are the product of the political process created by political human beings to help get them valuable resources, which could be civil peace and security, or a particular moral order, or power and influence, or even more goods and entitlements. For security, we have laws that eliminate traffic chaos, that enforce chaos, not chaos, eliminate traffic chaos, and enforce contracts. I need more coffee. That ban violence. For moral order, we have laws against murder, against incest, against rape. For political advantage, we have laws like those that give larger states greater power in the process of electing a president, and those that allow electoral districts to be drawn by the majority party. Laws that deal with more concrete resources are things that, like giving a tax break to a homeowner or subsidizing a dairy farmer. Different political systems produce different systems of laws. Small communities where people share values and experiences, there may be less of a need for a formal legal structure, since everybody knows what's expected of him, and the community can force compliance with expectations by ostracizing a nonconformer. There are here I am with a sword that I can't say, authoritarian systems like North Korea or China, where laws exist primarily to serve the rulers and the state. They're subject to change on the whim of the rulers. There are systems that merge church and state, like the Holy Roman Empire or some Islamic countries today. Laws are assumed to be God-given, and violations of the laws are analogous to sinning against an all-powerful creator. In non-authoritarian countries where citizens are more than mere subjects, can make the claims of rights against the government. Laws are understood to exist for the purpose of serving the citizens, even if they have to restrict our actions to do so. Laws and the courts that interpret and apply them perform a variety of functions in democratic societies where some of which we commonly recognize and others are less obvious. So there's 5 important functions of law. Y'all, I say this all the time, like this could be an entire class in law school and I'm giving it to you in 30 minutes. So we'll breeze through this and just kind of hit the high points. And one day when you go to law school, you'll learn even more about this. So 5 important functions of law. The first is that law provides security for people and for property so that we can go about our daily lives in relative harmony. This kind of follows directly from Hobbes and Locke, right? The second is that laws provide predictability. We can plan our activities in business without fearing a random judgment that would tell us we've broken a law that didn't even exist. Betsy is on the floor, but she says hi. The third is the fact that laws are known in advance and that they identify punishable behaviors that lead to the conflict resolution function of laws in a democracy, though through neutral third parties. Why can't I talk? Hold on. Through neutral third parties known as courts. Courts are the institutions that sit as these neutral third parties to resolve conflicts according to the law. Laws reflect and enforce conformity to society's values. For instance, murder is wrong and parents shouldn't be allowed to abuse their children. That's the fourth. And then the fifth is that laws distribute the benefits and rewards that society has to offer. And they allocate the cost of these good things, whether they're welfare benefits, civil rights protections, or tax breaks. So the American legal tradition, most governments in the industrialized world, like European countries, South America, Japan, Quebec, the state of Louisiana, because of its French heritage, they have a legal system founded on a civil law tradition, which is based on a detailed, comprehensive legal code that's usually generated by the legislature. This civil law tradition is a legal system based on a detailed, comprehensive legal code, usually created by the legislature. All right, some of these codes date back to Napoleon, the Napoleonic codes, and the codified system leaves little to the judge's discretion in determining what the law is. So the judge in these countries and in Louisiana takes more of an active role in getting at the truth. He investigates the facts. He asks questions. He determines what happened. The emphasis is on getting the appropriate outcome than on maintaining the integrity of the procedures, though fair procedures are still important. The U.S. is different in 3 ways. We have a common law tradition, we have an adversarial tradition, and we have a litigious system. So the common law tradition was developed in Great Britain and followed in the U.S., except for Louisiana. It's a legal system based on the accumulated rulings of judges over time, applied uniformly. It's judge-made law. We have an emphasis on preserving decisions that have been made before, relying on precedent, stare decisis, let the decision stand. This is a lot of what you spend your time on in law school. Precedent, obviously, precedent is in the past, right? A previous decision or ruling that in common law tradition is binding on subsequent decisions. Judges have a lot more power in determining what the law is than do judges in a civil law system. Their job is to determine and apply the law as an impartial referee and not to take an active role in discovering the truth. They're just more of the referee here in America, right? The United States is not purely common law, though. Legislatures do make laws, and attempts have been made to, goodness gracious, Attempts have been made to organize them into a coherent body of law, but legislators are less concerned with creating a coherent body of law than with responding to their constituents' needs. So American law has become a little bit hodgepodge. But with a common law nature that reinforces the fact that American judges still use their considerable discretion to decide what laws mean, and they rely heavily on precedent. So the United States as an adversarial system. So an adversarial system, that means like we have trial procedures that are designed to resolve conflict through the clash of opposing sides. Adversarial, you have an adversary. They're moderated by a neutral passive judge who applies the law. You're presumed to reveal the truth through the clash of skilled professionals vigorously advocating competing viewpoints. Judges have a passive role. They apply the law and they keep the proceedings fair and make the rulings when appropriate, but their role does not include that of active truth seeker. I clerked for a judge after I graduated from law school. His job was not to find the truth. His job was just to kind of be the referee and the lawyers who are presenting their cases. Okay, so we also have an inquisitorial system. These are trial procedures that are designed to determine the truth through the intervention of an active judge who seeks evidence and questions witnesses. This is the opposite of an adversarial system. It's intended to discover who did it. The judge is the fact finder. He's the one who questions the witnesses, seeks evidence, and the prosecution can have, and their defense can have comparatively minor roles. You can argue here that it maintains a key American principle that you are innocent until proven guilty. But here in America, we have decided that the adversarial system fits us better with our cultural emphasis on individualism and procedural values, and it gives a lot of power to the lawyers. So we have a very litigious system here in the United States, obviously. We sue each other a lot. There are more lawyers per capita in the United States than anywhere else. But other countries have other legal professionals other than lawyers who handle legal work sometimes. There are a large number of lawsuits in the United States. As we know, your coffee says, caution, this is hot, because somebody sued because their coffee was hot. It's a measure of our openness and our democratic concern for the rights of all citizens, and litigation is unavoidable in democracies committed to individuals' freedoms and citizens' rights to defend themselves from harm by others. We also sue a lot because we've failed to provide compensation and security from risk. Americans have come to expect total justice, that everything bad that can happen can be blamed on someone else who should compensate them for their harm. Lawsuits are costly to individuals. They are also costly to taxpayers. As a taxpayer, we support the system as a whole. We pay the salaries of judges. We pay the salaries of legal staff. Politicians make occasional attempts to limit lawsuits, but these are just, they have political motivations usually and don't really amount to much. Where are you going? You know. All right, so not all laws are alike, and there are shades of legal meaning. Substantive and procedural laws. So substantive laws, these are laws whose content or substance defines what we can or cannot do. The actual substance defines what we can or cannot do. Procedural laws, these are laws that establish how laws are applied and enforced and how legal proceedings take place. They are establishing procedures used to conduct the laws. Let me make sure she's not playing with something she shouldn't be. What are you doing? Okay, you're good. Oh, never a dull moment. All right, let's see if I can get a set back up here. All right, so sorry about that. Criminal and procedural, my little thing here is falling. Procedural due process or procedural laws that protect against the rights of individuals who must deal with the legal system. Procedural and substantive laws sometimes will clash though. Like, for example, if the police fail to read you your rights, but you can be spared punishments even if you broke a substantive law. So, you were speeding, but or you get arrested for something. You don't get arrested for speeding. The police didn't read you your rights. They broke a procedural law. Even though you broke a substantive law, you may be spared punishment. Let's see if I can get a set back up now that I knocked everything down. Okay, so criminal laws. We have procedure and substantive. We also have criminal and civil laws. Criminal laws obviously prohibit the behavior of government determined to be harmful to society. This is a violation of a criminal law. It's called a crime, right? refer to crimes against the state. So if a government prosecutes these cases, the government prosecutes these cases rather than like the family of a murder victim. The penalty, if found guilty, will be some sort of payment to the public, the community service, jail time, even death, because you are paying your debt to society right here. Your actions are seen as harmful to society in violating a criminal law. Civil laws are laws that regulate interactions between individuals. These are violations of civil laws. They're called a tort. You take an entire class in law school called torts. If one person sues another for damaging property, failing to fulfill a contract, this is not a crime against the state, but rather than a crime just to an individual. The government's purpose here is not to prosecute harm to society, but to provide individuals a forum where they can peacefully resolve their differences. The government has no stake in this outcome. Sometimes something can be both criminal and civil. For example, a person drives drunk and causes an accident that seriously injures someone. The drunk driver would face criminal charges for breaking the law while driving drunk, but they could also be sued by the injured person to receive compensation for the medical expenses, missed incomes, pain and suffering. That's called compensatory damages. That's the civil part of that. They could also sue the bar for serving someone too much alcohol, because people suing for compensation often target the involved party with the deepest pockets, who can pay the most. Civil suits can also include a fine intended to punish the individual for causing the injury. This is called punitive damages. Punitive means punished. So these are just fines intended to punish that. All right, constitutional law. This is the law stated in the Constitution or in the body of judicial decisions about the meaning of the Constitution handed down in the courts. What are you doing? Let me grab her. You do not need to be back here. How did you get back here? All right, you're gonna join me. You're getting too busy. All right. The laws in the Constitution establish the basic powers and limitations on government. They evolve as circumstances change, justices are replaced, and cases are overturned and precedent is reversed. Most laws in the United States are made by Congress and by state legislatures, by the bureaucracy under the authority of Congress, and by the president. Statutory laws are laws passed by a state or the federal legislature. They reflect the will of the bodies elected to represent the people, and they can address virtually any behavior. For example, wearing your seatbelt, paying your taxes, staying home from work on Memorial Day. These are statutory laws. Judges, under the principle of judicial review, can declare statutes unconstitutional if they conflict with a basic principle of government. So administrative law, this is law established by bureaucracy on behalf of government. Legislatures can't be experts on all things like we've talked about, so they frequently delegate their lawmaking powers to bureaucratic agencies and departments. And then executive orders we've talked about before. These are clarifications of congressional policy that are issued by the president and having the full force of law. All right. What about constitutional provisions and the development of judicial review? Americans may owe a lot of our philosophy of law, called jurisprudence, to the British court systems, but the court systems we set up to administer the laws is really uniquely our own. The nature of the judiciary was a subject of hot debate during our founding. Large states were comfortable with a strong court system as part of the strong national government they advocated, but small systems, cringing at the prospect of national dominance, preferred a weak judiciary, and so the founders left it to Congress to settle. Article 3, Section 1 says the judicial power of the United States shall be vested in one Supreme Court and such inferior courts as Congress may time to time ordain and establish. Judges hold their jobs for as long as they demonstrate good behavior. They're appointed for life, and they'll be paid regularly and can't have their pay reduced while they're in office. That's what the Constitution says about it. It doesn't spell out the powers of the Supreme Court, only which cases must come directly to them. And then so the Judiciary Act of 1789 kind of began to fill in the gaps on how the court system would be organized. Is it the least dangerous branch? Hi. The idea of an independent judiciary headed by one Supreme Court was a new one to the founders. No other country had one. Britain's highest court was also its parliament, the legislature. So this put a lot of faith in the idea of separation of checks and balances, separation of power. Independent judiciary was an ideal way to check the power of the president and Congress, and an important part of the narrative being created about limited power, but to others it created this unknown threat. So Hamilton said that the judiciary is the least dangerous branch because it doesn't have the power of the sword or the purse and can exercise neither force nor will, but merely judgment. In fact, several of George Washington's appointments to the Supreme Court turned him down because they thought that that was right and that they would have a more prestigious job somewhere else. When the capital was moved to D.C., the planners forgot to design a location for the Supreme Court, and the highest court in the land met in the basement of the United States Senate. When you guys are in Washington, D.C. one day taking your tour of the Capitol, make sure and ask your tour guide to show you the old Supreme Court chambers. It is really cool. It's still lit the way it would have been lit back then. You know, it's in the basement, so it's dark. They didn't have overhead lights, so they have these like little lantern kind of beside it. It's really interesting to see. Make sure you see that next time you're there. Eventually, they moved them across the street to the Supreme Court where it is now. So this low prestige didn't last for long, and that's almost single-handedly because of John Marshall. He created the power of judicial review, the power of courts to determine the constitutionality of laws. Marshall had the court create this power to allow the Supreme Court to review acts of the other branches of government and invalidate them if they're found to run counter to the principles of the Constitution. Hamilton kind of dropped a hint of judicial review in Federalist 78 that he would approve of a much stronger role for the court. This answered critics who declared that judicial review would give too much power to a group of unelected men. And Hamilton said actually the reverse is true. He said that since the Constitution is the clearest expression of public will in America, by allowing that document to check the legislature, judicial review would actually place the true will of the people over the momentary passions and interests that were reflected in Congress. All right, so then in Marbury versus Madison, the Constitution doesn't have the power of judicial review to the court, but it also doesn't forbid the court to have that power either. So Marbury versus Madison, this is the landmark case that established the Supreme Court's power of judicial review. And the case involved a series of presidential appointments to federal courts made by President John Adams in the final hours of his administration. The letter that appointed William Marbury to be the Justice of Peace for D.C. was overlooked and not delivered, so these midnight or last-minute appointments really irritated the new president, Thomas Jefferson, who wanted to appoint his own candidates. So he had his Secretary of State, James Madison, throw out the letter, along with several other appointment letters. So according to the Judiciary Act of 1789, it was up to the Supreme Court to decide if Marbury got his appointment. This really put John Marshall in a fix, though. If he exercised his power under the act and Jefferson ignored him, then the Supreme Court's already low prestige would be severely damaged. If he failed to order the appointment, the Supreme Court would still look weak. So instead of ruling on the question of Marbury's appointment, which was a no-win for him, he focused on the part of the act that gave the court the authority to make that decision. He found to go beyond what the Constitution had intended. That is, according to the Constitution, Congress doesn't have the power to give the court that authority. So Marshall ruled that although he thought Marbury should get the appointment, he couldn't enforce it because the relevant part of the Judiciary Act was unconstitutional and therefore void. So he justified the Supreme Court's power to decide what the Constitution meant by saying it's emphatically the province of the judicial department to say what the law is. He chose to lose a small battle in order to win a very large war. He created the power of judicial review, which vastly expanded the potential influence of the Supreme Court and set it on the road to becoming the powerful institution that it is today. It is very powerful today. It's striking that this enormous power that the court chose to give itself, what would the public reaction have been if Congress had voted to make itself the final judge of what is unconstitutional? But judges are really aware of the enormity of this power, so they don't use it a lot. It was not used since its inception in 1803 until 1859, with the Supreme Court struck down the Missouri Compromise. And then since then, it's only been used about 160 times to strike down acts of Congress, which is not a lot. Congress's response to, what are you doing? Congress's response to designing a court system immediately put together the Judiciary Act of 1789, but this system was too simple to handle the complex legal needs and the growing number of cases in the new nation. They gradually crafted, Congress gradually crafted it into the very complex network of federal courts that we have today. We have two separate court systems, the state system and the national system, and most actions take place at the state level. All right, so understanding jurisdiction here. Jurisdiction is who has the authority to hear what case. Most cases fall under the jurisdiction of a state court. You go to a federal court only if you qualify by the virtue of the kind of question raised or the parties involved. The choice of a court, though, is dictated in large part by constitutional rule. There are four basic characteristics that help determine what court has jurisdiction. First, if there was involvement of the federal government. The second, the parties to the case, if the state was involved or not. The third, where the case arose. And then the fourth is how serious of an offense it involves. Once a case is either in the state or federal system, it almost always stays that way. So original jurisdiction is the authority of a court to hear the case first. Appellate jurisdiction is the authority of a court to review decisions made by a lower court. So when you appeal something, this is a rehearing of a case because the losing party in the original trial argues that a point of law is not applied properly. Almost all cases come to the Supreme Court on appeal. Supreme Court's original jurisdiction is limited to cases that concern like ambassadors, public ministers, cases to which state is a party. This usually amounts to no more than 2 or 3 cases a year. And then state courts, each state has its own constitution and its own set of rules for structuring and organizing its system. They're pretty similar to each other and to the United States Constitution. But state courts usually fall into 3 tiers. The trial court, which is like county municipal courts. That's where I worked. The second is an intermediate court of appeals, and that's in Columbia. And then the state Supreme Court, and then we have that in Columbia also. Each state has a varied name for these. They're appeals courts, so no questions of fact can arise. There are no juries. There's a panel of 5 to 9 justices who meet to discuss the case and make a decision. It's a court of last resort. So judges in state courts are chosen through a variety of procedures specified in the individual state constitutions. They range from being appointed by the governor or elected by state legislatures to being elected by the state population as a whole. So that is a very controversial question. Should a judge be elected or should they be appointed? They're very controversial. People say that by electing popularly a judge, this gives the people a voice and can hold the judges in line with public opinion, but it also says that it can create a conflict of interest. For example, the Chamber of Congress regularly spends time in court, and so they spend a lot of money to influence judicial elections across the country. Others maybe argue that few people are able to cast an educated vote in a judicial election, and that a threat of defeat may influence a judge's ruling. So here in South Carolina, our courts are appointed by the legislature. Hey, what's that about? The federal system is also 3-tiered. It has the same thing. The entry-level court is called the district courts. It has the appellate level and then the Supreme Court at the very top. There are 94 district courts, and then the courts of appeal, there are 12 circuits of those, and then you go to the Supreme Court. The Constitution is really silent about the selection of the federal judges. They should be appointed by the president with advice and consent of the Senate. They should serve lifetimes of good behavior and can only be impeached, or can be impeached the same way a president can. Federal judgeships are awarded on the basis of a few different criteria: rewarding political friendship, cultivating future support. But courts are pretty demographically uniform, white, male, Christian. This has changed some. Obviously, we're about to appoint a woman, Amy Coney Barrett, today, and she is Catholic, which is interesting that that's even something that anybody would talk about. An important qualification is the ideological policy positions of the appointee. So if you're president, you want to nominate a justice that's going to have similar ideology as you. But the increasing politicization, wow, why can't I talk today? Really means that a lot of the president's nominees are facing grueling battles in the Senate now. Even if they get a vote through the Senate Judiciary Committee, sometimes they're lucky if they get a vote on the floor. But right now, we are getting a vote on the floor today. So the Supreme Court, this is the very top of the nation's judicial system. They don't wear the elaborate wigs of the British colleagues in the House of Lords, but they do wear long black robes and sit against this background of red silk. This is the closest thing we have to pomp and circumstance in the American government. But the Supreme Court, even after the contested election of 2000, the Supreme Court gets higher ratings from the public or Congress gets higher ratings from the public than Congress or the president does. They don't suffer much from the popular cynicism that the government that affects the other branches. They're seen as above politics. You are so loud. The founders wished for them to be really above politics, which gives them more force and legitimacy, but they're not completely removed from politics. They're intensely political in how they are chosen, how they decide what cases to hear, how they make decisions, and the effects of the decisions they make. So how are members of the Supreme Court are selected? In a perfect world, we'd select the wisest, most intelligent jurists to be on the Supreme Court, but in a political world, we need that to be balanced against who that elected president chooses and how a Senate can confirm them. On paper, the process for choosing a justice is not much different than a federal judge. There's no tradition of any sort of senatorial courtesy or anything, but the composition of the Supreme Court does have serious political consequences. The Constitution doesn't provide a handy list for, you are so loud, my goodness. Doesn't provide a handy list of criteria for making these political appointments, but the demands of a president suggest that merit, shared ideology, political reward, and demographic representation all play a role in this choice. So merit, you want the highest, most qualified person with highest ethical standards, who also meet the other prerequisites. The FBI also checks out the background of nominees, although sometimes critical information is missed. I don't know if you guys remember the Kavanaugh hearings of a few years ago. Justice Brett Kavanaugh was nominated by President Trump to serve on the Supreme Court. He then had someone come and accuse him of some inappropriate conduct when he was in high school, and it became kind of a he said, she said, did he or did he not? The FBI had to get involved and find out, what they thought about these accusations. He ended up being nominated, or he ended up being confirmed, and he is a Supreme Court justice now, but it really brings about a lot of questions to what the FBI can dig up about you. The Reagan administration had a widely publicized Just Say No to Drugs campaign, and they nominated a Supreme Court nominee who had used marijuana in college and while he was on the faculty of Harvard Law, so he had to withdraw his name from consideration. Clarence Thomas in 1991 was also accused of sexual harassment like Kavanaugh. He was also confirmed, but this brings about a lot of ethical questions about Supreme Court nominees. So the president also wants to appoint well-qualified candidates, but he's constantly constrained by the desire to find candidates who share the views of him on politics and the law. They can have the traditional liberal conservative dimension, but they can also take the view that the Constitution means exactly what it says it means. That's strict constitutionalism, a judicial approach that the Constitution should be read literally with the framers' intention at the utmost in line, or judicial interpretivism. This is a judicial approach to holding that the Constitution is a living document and that judges should interpret it according to a changing time and value. So sometimes it's hard to know if, when a president nominates somebody where they fall on that scale. Most of the nominees to the Supreme Court have been personally acquainted with the president, and they're trying to be kind of repaid. They've been a good friend to the president, and the president is rewarding them in an impressive fashion. The president wants to appoint people who represent groups they feel should be included in the political process or support they want to gain. So Trump is appointing a woman because he's looking out for that constituency right now. LBJ appointed Thurgood Marshall. He wanted to appoint an African American. I don't know where that just went. And then George W. Bush appointed Clarence Thomas to fill that seat, to maintain an African American in that seat. So to be confirmed by the Senate, the Senate must approve the presidential appointment to the Supreme Court. The Senate judiciary plays the largest role in holding hearings, inviting the nominee, colleagues, and concerned groups to testify. Sometimes the hearing, sorry, my phone is blowing up. But as the appointments have become more and more ideological when the Senate majority party is not the party of the president, the hearings have had the potential to become political battlefields. So then the Supreme Court has to also choose, another way they're very political, they have to choose what cases to hear. And politics makes an appearance at that. They can't hear the approximately 8,000 petitions they hear each year. So there are about 80 or 90 cases they hear each year. This is a political process in determining what those will be. Almost all of their cases come from an appellate, not original jurisdiction. And they are come in the form of a writ of certiorari. These are formal requests to call up a lower court case, which they hear on appeal. For a case to be heard, it has to be within the Supreme Court's jurisdiction. It has to present a real controversy, and not just looking for the Supreme Court's advice on an abstract principle. So the law clerks in the Supreme Court are usually recent law grads who have a lot of responsibility. They have to read all of the writs of cert. They have to summarize the petitions and then present them to their bosses to say what should be heard. Okay, so the rule of 4. This is an unwritten requirement that Supreme Court justices must grant a case of certiorari in order that 4 Supreme Court justices must grant a case of certiorari in order for the case to be heard. It takes fewer people to decide to hear the case than it will eventually take to decide the case itself. That gives a lot of power to the minority on the court. Some other influences, whether the United States is a part of the case before it, if it's going to be in front of the Supreme Court. The Solicitor General is the Justice Department officer who argues the government case. They're also influenced by amicus briefs. These are amicus curiae briefs. These are called Friends of the Court documents that are filed to encourage the court to grant or deny certiorari. And then to decide a case. Once the case is on the docket, the parties are notified and they prepare their written briefs and oral arguments for the Supreme Court appearance. Lawyers for each side get a half hour to make their cases. They're often interrupted by justices who want to seek clarification, criticize points, offer supportive arguments. This half-hour rule is followed really strictly, and so you've got to really be on your feet if you're in front of the Supreme Court. Okay, and so then now the Supreme Court has to decide your case. The Supreme Court has a variety of factors that affect the justices when they're making their decisions: their attitudes, their values, their beliefs, some external factors, their attitude toward the Constitution, and if it should be how literally the Constitution to be taken is important. Judicial activism. This is the view that courts should be lawmaking, policymaking bodies, or judicial restraint, that the courts should reject lawmaking functions and stick to judicial interpretations of the past. That's something that's always going on. External factors. These are justices who make decisions that are maybe consistent with the majority opinion in the United States, mostly because the same forces that shape political opinions are also that justice's opinions. You know, they're reading the same news we are a lot of times. So once they've just reached a decision, they have to write the opinion. The opinion is the written decision of the court that states the judgment of the majority. This is the lasting part of the process. This is what's read by law students, by lawyers, by judges, by future justices. It's what's vitally important for deciding how the nation will understand what a decision means. A concurring opinion is a document written by justices that express agreement with the majority. A dissenting opinion is a document that expresses disagreement with the majority. The other opinions have lasting impact as well. There are a lot of political effects of a judicial decision. John Marshall's enhanced power of the federal government over the states by declaring the Supreme Court had the power to invalidate laws as they conflict with the Constitution. In the early years, the Supreme Court was an ardent defender of the right of businesses not to be regulated by the federal government. The role of the Supreme Court in civil rights is well known. And then obviously Bush versus Gore. These are other political effects. What about the citizens in the courts? You know, this chapter argues that the legal system and the American courts are central to the maintenance of social order and conflict resolution. And they're also a fundamental component of American politics, of who gets what and how. But the central question for the American democracy is who takes advantage of this powerful system for allocating resources and values in society. It's important that we all be treated equally under the law. But citizens are treated differently by law enforcement all the time. We don't necessarily have equal access to the civil justice, the justice system. We have public defenders who, who take cases to represent people who can't pay on their own. And then the same thing in a civil system, you have what's called legal services, and that's a nonprofit that helps provide resources to people with legal problems that aren't criminal problems, like housing, employment, family issues, finances, and immigration. It's a little more controversial. All right, that was kind of a mouthful. I'm sorry, that was longer than I anticipated, but it's a really interesting time to be watching Supreme Court nominations. If you have a chance to watch the vote tonight, give it a listen. It'll be interesting to see Amy Coney Barrett become a Supreme. I fully expect that she will get the vote and she will be nominated as our next Supreme Court justice. All right, if y'all have any questions, reach out to me. I'm coming back tomorrow with one more lecture, and then we again are going to have our second exam next week. All right, talk to you soon. Bye.